Good afternoon, ladies and gentlemen. We still have about a minute or so, so I see there are still a number of people logging in. So as soon as the bulk of those that have registered signed in, I will start the session. Good afternoon, ladies and gentlemen. Welcome. Thank you for attending this presentation. My name is Jan de Tooy, and it's proudly brought to you by the Mediation Institute of South Africa, another information session. Contact details of the Mediation Institute on the screen, ladies and gentlemen. So if you need a mediator, you're welcome to drop us an email or contact the telephone number on the screen. Right, so ladies and gentlemen, the second session today, a couple of speakers, quite an interesting topic, very relevant to many of you folk that, or relevant to some of you that may have gone through a divorce, and some of you, hopefully, that are not in the process of going through a divorce. So, family mediation, and a number of speakers that will today entertain you. Right, so the first speaker will be Viraj Shrikerson, Director of Fair Practice. She's an ADR trainer, ADR, ODR International Civil and Commercial Mediator. And I see that Viraj just joined us. Welcome, Viraj.
Hello,
Then,
everybody.
good afternoon. Then the second person on the list, not in any specific order today, Advocate Liana Badenhorst, also of the Mediation Institute of South Africa. She's a practicing advocate and also an ADR ODR International Civil and Commercial Mediator. Good afternoon, Liana. Right, and there we go. I see Liana came on. We can see
Thank
you,
you.
Liana. Hello. Right, then Gunther Williams, also the Mediation Institute of South Africa, also International Civil and Commercial Mediator, Patton Williams Attorneys, all the way from Cape Town. Good afternoon, Gunther. How's the weather in Cape Town today?
Beautiful as always. Good afternoon, Jan, and everyone else. Beautiful and happy to be here.
Great, welcome, Gunther. And we also have Mr. Ranier Bosov, a regional magistrate, Gauteng South, ADR, ODR International Civil and Commercial Mediator, all the way from Centurion today. Good afternoon, Ranier.
Good afternoon, Jan and everybody.
Great, welcome. And then, last but not least, we have Nasli Williams, the Mediation Institute of South Africa, also a civil and commercial mediator, also from Patton Williams Attorneys. Good afternoon, Nasli.
Hi, Jan. How are you?
Well, and yourself, I think your camera feed is off. If you can just quickly switch it for us on.
Okay.
There we go. We can see you. We can see you. Good
Hi.
afternoon, Nasli. Also
Hello.
from Cape Town. Right. Thank you for that, ladies and gentlemen. Now that you've seen all the presenters, the speakers for today, just a couple of formalities. The session will be approximately 1 hour. What we will discuss today, the first speaker, Introduction to Family and Divorce Mediation. Ranier will talk about court processes after agreement that was reached and the effect of poorly drafted agreements. Liana, Parenting Plans and the Children's Act, followed by Nasli, the attorney's duties and responsibilities to their clients, and in terms of Rule 41A, consequences of not mediating, some interesting information that she will share with you. And then Gunther, mediating family business disputes. And I'm sure that could be quite tricky and messy if not handled or managed in the correct manner. Right, then some housekeeping before we continue. Internet connection, ladies and gentlemen, we have very stable internet connections on our side. However, from time to time, things may go belly up. If signal is lost, it will flag on my side and I will be able to correct it. However, if there's something wrong on your side, it will pop up a message on your screen that you have a poor connection. Just wait a couple of seconds, it should stabilize. If not, then the best advice is to disconnect your internet. So disconnect your Wi-Fi connection and reconnect. That will normally solve the problem. Now, on your screens, you will see at the bottom a little hand and a Q&A function. Right, now, if you click on the hand, and I know you are all burning to do so, so now I'm giving you permission to do so. If you click on the hand, yeah, there we go. I can see all of you are clicking on the hands. It flags on my side, and that's all it does. It does not unmute your microphone or your camera. However, today, ladies and gentlemen, we are not going to attend to you raising your hand. We have a number of participants today, or attendees, and it's virtually impossible to interact with everybody on a one-to-one basis. So you can now also lower your hands. Now you have the opportunity to click that button, and we're going to lower all hands. However, the Q&A function, you will see if you click on that, you can type out a question. And that question will pop up on our screens, and we will either reply by means of a text reply. Alternatively, one of the presenters will answer your question live. So please, I'm old school. I do not understand all the abbreviations used these days in electronic communication. So if you can keep it plain and simple for us to understand the question, we will try to answer as many as possible during the course of this presentation. Right, I may also ask you, and as a matter of fact, I will ask you to participate in a couple of polls. It's really just for background information for our sake. The first one I'm going to pop up on the screen in a couple of seconds' time. So if you can kindly participate, the information is confidential. I can't even see who indicated what in the poll. So please participate. We will really appreciate that. Right, ladies and gentlemen, and before our first speaker, I'm going to launch the poll. So if you will just give me 1 second to quickly pop up the first one for you to kindly participate in. And the first one is, in which sector, from which sector are you? If you can kindly answer, and you will see it on your screen right now. And if you see me looking to my right-hand side, it's not because I'm being distracted. I have another screen that I work from, and I see that we've had almost 50% response so far. So I'm going to keep it open for another couple of seconds. Great, thank you very much. I see that most of you participated. Thank you very much for that. I'm going to end the poll so that you can see the speakers. And the first presenter today or speaker will then be Viraj. Viraj, you are welcome to unmute your camera. There we go. Viraj, the internet is yours.
Thank you very much, Jan. Thank you, everyone, for joining us today. And good afternoon to you all. Some of you may have joined us in our first session last week. So what I'm going to say, just as the introduction here, might be, you might have heard before. So I just want to recap, and for those who haven't heard this, this is information for you as well. So since mediation has become more recognized in our legal system as a cost and time-saving mechanism to resolve disputes amongst other benefits that it has, and in light of the recent High Court Rule 41A, which you will hear about more today, I'm sure we will start to see the courts requesting that parties go to mediation more often and to seriously consider using mediation to reach a resolution. So today we're going to focus on family and divorce mediation and what you should look out for in these mediations. Firstly, mediation is a structured process whereby a mediator, who is an independent, impartial, and neutral person, facilitates the negotiations and discussions between the parties or the participants on issues determined by the parties and participants and on issues they want to make decisions on. So the basic principles of mediation quickly are that it is voluntary, you can choose to attend, and you can also choose your mediator. However, if it is mandated, you can attend and then you choose to remain in mediation to reach agreement. However, should you choose to terminate the mediation without good reasons shown, the courts may question why the parties did not reach agreement in mediation and may either send the parties back to mediation or make a cost order if mediation was not used appropriately. Mediation is a confidential process, and there are many levels of confidentiality which begin in most instances the moment you start contacting the mediator. It is also done without prejudice, so these discussions and negotiations that are facilitated by your mediator cannot be held against you outside of the mediation. Or you can enter into it knowing that it is not cast in stone, but rather written in sand, and you can come back and renegotiate on those discussions. There are exceptions to these basic principles, and that is if the mediator is aware of criminal activity or impending criminal activity, then the mediator must inform the parties that this information cannot stay confidential. Now, when you're going to divorce mediation and family mediation, who is your mediator? Again, you choose the mediator, and that mediator must be competent and properly trained. So it is not your lawyer or attorney or any legal representative. It cannot be someone who either of you believe is likely to be biased. The mediator has to be impartial. They must have no vested interest in the outcome of the mediation. If you have a lawyer that's representing either one of you, chances are that that mediator cannot maintain impartiality if they're going to represent one of you in court. So it's not ideal to use that person. However, that person does stay relevant in your proceedings. So we're not saying get rid of your lawyer, and we'll talk about that later. So the mediator does not make decisions on behalf of the parties, and the mediator does not give a judgment or make a finding or finds in favor of one party over the other. Do not be intimidated by the process, because using mediation does not mean you give up any other rights to access to justice or access to the courts. You still use the process of mediation to reach resolution and to receive information. What the mediator does is that a competent mediator will improve communication between the parties and assist them to define their issues and facilitate their discussions and negotiations in a proactive way. So the mediator will give information that is relevant to your issues and will not advise you. So for instance, the mediator will inform the parties on what law is relevant to that particular issue, but will not advise the parties on how to apply the law to win a point over that party in the negotiation. The mediator should also not say things like, well, when I got divorced, this is what I did, and maybe you should do the same because it worked for me. The mediator must at all times remain impartial. So while the mediator uses their skills to move the parties into a constructive direction, the mediator must also manage any power imbalances that they see in that process. So because the mediator must ensure that everyone gets a fair chance to be heard and to present their versions and to go through all the relevant information and objective criteria in order to make informed, realistic decisions. Where there is instances of alleged domestic violence, the mediator will approach with caution, and if the process of mediation is not beneficial or the environment is not safe for the parties, the mediator may postpone the mediation for further investigation or terminate the mediation as a whole. It is the mediator's discretion. The parties control the outcome and the decisions made, and their lawyers may provide advice where they're necessary, but may not necessarily be part of the mediation proceedings. So you can consult with your lawyers. However, your lawyers, if they are part of the mediation process, must provide value. So the mediator communicates directly with the parties, and any lawyers who attend mediation and frustrate the mediation process, the mediator will give them the status of an observer or as an observer, and they can only be consulted with during the breaks. Now, if you've decided to mediate your issues in terms of a divorce or separation, in these discussions, which are especially around children, I want you to understand that these processes can be used whether you're married or unmarried. And when we need to talk about specific relationship statuses, understand that there are slight differences in terms of the documents that you require, but most of the information that you receive today will be a generalization of the information. Now, the underlying principle in our discussions are based on the breakdown of the relationship, and that the relationship that you have is at a point where it cannot be retrieved. However, I want to point out that you can use mediation to salvage your relationship as a family. So if there are any obstacles that you're facing, you can use mediation to overcome these obstacles and move your family forward as a unit. So when I'm talking today, when all of us are talking, I want you to keep in mind that we're not excluding anyone. So you could be married, unmarried, living together, talking about separation or divorcing each other, currently separated, thinking about getting divorced, or have begun divorce proceedings, or in the middle of exchanging documents or pleadings between each other. You've heard that mediation saves time and costs, and you want to explore how it assists you and your family. Now, you could also be post-divorce or a court order has been granted. However, the terms of agreement are not applicable to your current circumstances. You could be post-separation, and even though unmarried, you both have a child or children, but no contact or care arrangements have been formally documented, and winging it is no longer working for both of you as co-parents. So, or you could be at a point where your children are at the age where your divorce or separation agreement is not sufficient. Now, mediation is possible in these circumstances and also can be used in collaboration with other professionals, for example, financial advisors, psychologists, social workers, actuaries, and lawyers. You can also use mediation if there are no children. So you may only talk about issues such as maintenance or division of assets. Now, when you are going through mediation, what is it that you expect from the process? Firstly, you both need to find a mediator, and you can discuss with your partner or spouse which mediator you want to use and if this mediator is appropriate. One of you or both of you may contact the mediator to set up the sessions, and regardless of who makes that first call and fills out the intake forms, the mediator's duty at all times is to remain impartial. So once you've entered into an agreement to mediate, you can also discuss how costs are being shared or determined either on a pro rata basis, 50-50, or one of you can decide to pay all of the costs. You now attend these mediation sessions. They will be either individual sessions or they will be joint sessions, and the mediator will decide what is best for both of you in this process. You must choose a mediator you are comfortable with and who is competent, again, on your issues, and that you both trust that this mediator is not biased. I want to always stress that mediation is not therapy or counseling, so there's no diagnoses made on behaviors or an analysis of behaviors. The focus in mediation is the future lives of the family. Using mediation, the mediator understands that this is an ongoing relationship between you and the other person, and this has to be preserved sometimes for the sake of the children. So the mediator will be forward-thinking and communication will not be antagonistic. Instead, the mediator will mentor both of you and teach you or work with you to communicate effectively. Now, in the process, you will not be presenting a case to the mediator. You will not be providing evidence unless it is objective criteria that moves the negotiations forward. You will explore options and you will attend as many sessions as you both need to reach agreement. An ethical mediator will ensure that you do not cause unnecessary delays and prolong the process that is detrimental to both of you as a client. In some instances, mediation can resolve your issues within 30 days. However, mediation always leaves the door open for parties to come back and mediate on issues that they have not resolved or they feel they have not made realistic decisions that are capable of being fulfilled. Use mediation to determine the agreement, which will be discussed again later on what you do when you've reached that agreement. However, if you don't reach agreement, it is still not a waste of time. At least you get to understand the perspective and the issues that are in dispute. So in mediation, divorce mediation or separation mediation, you will discuss issues that related to the contact and care of your children, which you'll hear more about. You will have documents drafted in terms of a parenting plan if you're married parents, or you will have a parental responsibilities and rights agreement for unmarried parents or anyone interested in the well-being of the child with permission from the mother. These documents will explain in detail the differences and why they're drafted in that particular way. Please know that it is mandatory for co-parents to mediate on these documents. This is because the details contained in these plans and agreements are specific to those children and those parents. You should not be in a mediation where the outcome is a generic agreement or the parenting plan is something that the mediator says is a one-size-fits-all approach. Your mediator must go into absolute detail around the specifics of the decisions made and how realistic they are for you as co-parents and relevant to your daily lives. For instance, if the parent is working shifts or lives in a different location, it must revolve around the best interests of the child and what the parents are capable of fulfilling on that parenting plan or agreement. Both of you will come to realistic decisions, and you must understand that having these contact schedules, which is also known as access, and the care, which is normally referred to as custody, you must go into the details that pertain to your particular child. But again, these documents are evolving documents. So they will move along in terms of your child's age, development, and maturity. In conjunction with that, the mediator will call for or inform you about child participation. So your children have a constitutional right to be heard and their views and be taken into consideration. So your mediator must be able to inform you about this, but this does not mean that the decision-making sits with the children. The children are there to express what will work, what will not work, and possibly give reasons as to why it will not work, and that may influence the final decisions that you make in mediation. So be informed that you will be asked in certain instances, and depending on the age of your child and maturity of your child and the developmental state of your child, that the child be involved as part of drafting these documents. In these mediations, you will also talk about maintenance for the child, maintenance for the spouse. And what is great about mediation and the flexibility of mediation is that you get to talk about maintenance that is based on either a pro rata basis that can be calculated, 50-50, or sometimes you can talk about one parent taking on specific costs and then using pro rata basis for other costs. Again, it's based on the needs of the child and the affordability that the parents have. Maintenance also does not stop when the child is 18 years old, and maintenance must provide for when the child becomes self-supporting. You can also discuss calculations of the increase. So maintenance mediation allows for you to do that, and you get to determine the percentage or use a CPI increase. In mediation, you also discuss the division of the assets. So while you may be bound by your marital regime, there are concessions you can make in which you can talk about items that have sentimental value or particular items that you want the other to take ownership of, or split the assets in a way that is more practical for you both. Again, we're not saying don't pay attention to the marital regime, but you can discuss what is more efficient and part of what you want to split between each other. Remember that the documents that you draft in mediation are evolving documents, so they will change depending on your circumstances. So the mediator must talk to you about a review clause or coming back to review any circumstances that have changed, then these changes need to be made on these documents. So why go into mediation? Well, your mediation can be done, again, in the shortest possible time that is relevant to the two of you, but you're not rushed, and you benefit from having to discuss and understand each other's perspective. Remember that in mediation, that even though you have a written detailed document detailed to your specific circumstances, you may discuss any other issues that you feel will improve the relationship going forward. You will have the option to reality test your decisions and then decide finally on what final decisions you will make that will work in those instances. So engage in mediation in good faith, and if you have children, understand that the standard there should be in the best interest of your children. And with a competent mediator, these processes will be beneficial for you all. So I hope that is able to help you understand a basic and general understanding of family or separation and divorce mediation. Thank you, Jan.
Thank you very much, Viraj. Very insightful presentation. I see a couple of questions that came in, and if I'm going to put the questions out there for the rest of the presenters as well, if any presenters able to answer. So let's first look at the first question, anonymous. Good day. What is considered appropriate, and maybe slightly off the topic, Viraj, so maybe you can assist, Nasli, your field of expertise as well. What is considered appropriate contact for a teenager to have with the non-custodial parent?
Okay, so depending on, and this is not advice, so depending on the needs of your child, depending on what, for instance, their extracurricular activities, or if they're capable of doing a shared residency where they can do 1 week on or 1 week off, it all depends on what your child is comfortable with. So that's why we encourage child participation. As parents, you can make those decisions, or you can put those on the table, and then ask the child what they are comfortable on, what is practical. What can the parents facilitate in terms of their own responsibility? So if you have a parent that's working difficult shifts, or you have a parent who's incapable of giving that amount of time, again, all of you sit down and work out what is the most realistic contact schedule there.
Thank you, Viraj. Nasli, I see you've joined us as well. So another question that came in, but maybe between the two of you, and again, slightly off the topic maybe, and I'm not going to give the name of the person that asked the question. I know the father has every right to see his kids, but he refuses to pay any maintenance, and now I'm having to fork out money to apply for the divorce as well as court. He's also sent a plea claiming I'm insane and mentally unstable, that the kid should not reside with me, yet he left last year, and I've been the sole provider and the only caregiver for all 4 children. How do I go about, because this is killing me financially? Do you have a bit of wisdom to share, either Nasli or Viraj or any of the other participants?
I think I might be able, just a disclaimer, of course, this is not legal advice. This is merely guidance that I can give. It is important that you seek legal advice, of course, from your own attorney. Jan, if you can just read the first 2 sentences of that question, please. She wanted to...
She says that she acknowledges that the father has every right to see the children, but he refuses to maintenance. And she now has to apply to for the divorce and court, etc.
Okay, so you are still married then. Well, in such a case, of course, you have to institute divorce proceedings. If you can't afford an attorney, you can apply to legal aid or to probono.org, but you can also just attend the regional court. I suggest the regional court, and you can go and complete the divorce forms. There is a process that you can use, Rule 58, in terms of the court rules, where you can claim interim maintenance while your divorce is pending or while the divorce is not yet finalized. So assuming you're going to go to the regional court, I think you must, as soon as possible, attend to the regional court, fill out the files, the forms, ask the clerk, the divorce clerk, to assist you. Take your marriage certificate, take your children's birth certificates, please take a proof of address. They always ask that. But the Rule 58 application, you won't be able to do it with your divorce form. So I suggest that you make an appointment with an attorney. Usually the first consultation is not that expensive. Maybe they can assist you in maybe drafting your own Rule 58 application for interim maintenance. Unfortunately, I can't explain to you the whole process during this break, because this is obviously for mediation. But I think if you feel that you could mediate, or if you could talk to your spouse about maintenance and getting divorced, perhaps you can also suggest to him mediation. But the worst case scenario, if he does not want to mediate, is that you need to approach the court to fill out the forms and to apply for a Rule 58. But I suggest you try mediation first, because oftentimes one of the parties just wants some direction. I want to do it, but what do we do? So maybe suggest our institution and see what we can do for you.
Great. Thank you for that, Nazli. I see the attendee asked the follow-up question, and I recommend that you contact the Mediation Institute for the contact details of Nazli for further assistance. Right, so our next speaker today, Ranier Bosov. Ranier, are you there?
Good afternoon, everybody. My name is Rene Bosov. I'm a regional magistrate with over 27 years experience in the adjudication of legal disputes. I've seen firsthand the effect of badly drafted divorce settlement agreements. The divorce process in South Africa is fairly straightforward, yet the financial and emotional consequences can be profound, to put it mildly. Most divorces are currently lodged in the High Court, although the Regional Court Amendment Act that came into operation in 2010 alleviated this position somewhat, granting also jurisdiction to deal with divorces to Regional Court magistrates. Two sets of rules are applicable. There's the High Court rules and the Magistrate Court rules, depending on the forum that you choose. There are minor differences between the two forums, especially with regard to forms, prescribed, etc. The harsh reality in South Africa, however, is that we are dealing with backlogs. The court rolls are overly burdened. So to get a trial date in your divorce matter, especially where it's contested, you will have to wait a long time. It speaks, therefore, for itself that divorce proceedings, with or without a lawyer, will be substantially cheaper and quicker if uncontested. In other words, if it is mediated beforehand, either with the help of a lawyer and or a trained family mediator, or even do it yourself when you mediate it yourself. It is always advisable to contact a lawyer and or a trained family law mediator when dealing with divorce issues, as the register or the divorce clerk at the regional court may not be always available to give you legal advice. Issues like guardianship, primary care, matrimonial property, spousal and child maintenance, the effect of inflation, the interest of children, contact or access to the children, non-variation and waiver clauses, breach, confidentiality, and the specific terms of the settlement must be carefully considered and drafted. Whether the parties like it or not, they are normally intricately involved because they share children. There's a definite ongoing relationship that need to be defined and for these changes to be implemented and lasting. You don't want to see the parties approaching the courts every second day or every second week. These changes must be properly implemented and lasting. There's always the best interest of children that must prevail, parenting plans, all to be factored into settlement agreements. The speakers after me will discuss these issues in much greater detail. Rule 41A of the High Court rules now also firmly introduces mediation as a pre-litigation step. It came into effect 9 March this year. Even regional court magistrates, although they can't instruct parties to go for mediation, often ask parties to go for mediation. Friendly, but making it basically compulsory. The pro formas used in the different courts are very self-explanatory. It does not really warrant discussion. If unopposed, the divorce application land up on an unopposed court roll. The defendant can also file a notice of intention not to defend. Then only one party will normally attend court, and the settlement agreement would then simply be made an order of court. The procedure is very similar in the High Court. Special arrangements are in place now during the COVID-19 pandemic, where the parties have referred their dispute to mediation and where the parties have settled the dispute with the aid of a mediator. The mediator must normally assist the parties in drafting a signed written settlement agreement. Even where mediation reached a deadlock or where it was not successful, it's not entirely useless normally, as the parties can still agree upon the issues that's in dispute and define it a bit better, very much like in a pre-trial conference. And they can also reach agreement on other issues. It is also possible to mediate only certain aspects of a divorce and or a family dispute. Now, it is a harsh reality, although divorce or settlement agreements are entered into every day, they are often prepared in haste at court, scribbled down on a pad, signed and presented to a judge, anxious to clear the court roll. There's also the DIY proceedings where the parties are undefended, they do their own thing, and where they might not necessarily consider all the relevant and important aspects. I see way too many divorce decrees and orders drafted hastily or DIY without considering future increases or changes, having profound financial and emotional consequences. The Mediation Institute of South Africa can definitely make a huge contribution in this regard. Trained and experienced family law mediators will definitely render an invaluable service to the courts. They would be unbiased, procedure and cost effective with all the parties, not only some best interest at heart. Thank you very much.
Thank you very much, Ranier. Again, another insightful presentation, and I see a lot of questions that came through, which I will put to the panel in a minute's time. Ladies and gentlemen, if you can just kindly assist me with another poll that I'm going to launch Just quickly participate. It should be on your screens in a second's time. There we go. It should be on your screen. If you can just kindly participate. Thank you. I see the votes are, or the information is coming through. I'm going to keep it open for another couple of seconds. There's a question: when paying mediator fees, could it create a problem? For instance, I paid, so I am the client. I don't think a mediator has a client as such working for all the parties. Or am I wrong in thinking this way? Martin, you're 100% correct, and that is something that is agreed to between the parties in the agreement to mediate as to who will pay, and then typically it will be a combination, both parties paying for the services of the mediator. Right, so thank you very much for participating in the poll. I'm just quickly going to end this poll. Thank you, ladies and gentlemen, and we're going to take one or two questions, and if I can ask the panelists to just quickly unmute their microphones and cameras, and let's start at the top. A lot of questions pertaining to training. Will training be offered? Most definitely. So you are welcome to drop us an email at info@mediate.co.za. I'm sure that your email address will be kept on file. We have not yet finalized the courses and all the detail surrounding that, but you are welcome to so long inquire. And then starting at the top, is the parental agreement finalized at court binding? What recourse is available if the other party does not adhere? Ranier, are you able to answer this one?
Sorry, Jan, can you just repeat the question?
Right, so the question is the parental agreement finalized, that is finalized at court, is it binding, and what recourse is available if the other party does not adhere?
Good. As the recourse, once it is final, once it's made order of court. So it forms part of the annexure that's attached to the divorce proceedings, and then the final court order is made, making it final and binding. So the recourse is when there's a contravention of the parenting plan, that is basically a contravention of the court order. It's contempt of court, and you can approach the court for assistance.
Thank you very much for that. And then, Viraj, I'm sure that you will be able to answer this one as a trainer. Can mediation be done online, like via Zoom or Teams meeting, for circumstances where the parents are worlds apart? So the father is in maybe in South Africa and the mother in Germany. What's your view on Zoom, Teams, video conferencing mediation?
You're talking about something we've been talking about for a while.
Yes.
Yes, mediation over Zoom or Teams is just as effective as if you were in person. So you're not losing anything. You actually benefit from being able to mediate through using these applications or these programs, because the mediator still is able to have the joint sessions, have the separate sessions. You can discuss anything on the same day in breakout rooms. It is exactly the same thing. You're just not in person. And the well-trained mediators, you don't lose out on communication skills. You don't lose out on picking up body language or anything like that. Well-trained mediators are fully capable of running these mediations online. So go ahead and use it.
Thank you very much for that. And then that takes us to our next speaker, Liana. Liana, are you there? There we go.
Yes.
I can see you, Liana. And the internet is now yours.
Thank you. Yes, my name is Liana Badenhorst. I'm a practicing advocate here in Pretoria on Groenkloof Chambers, also a mediator and arbitrator in matters. So good afternoon, and thank you for giving me the opportunity to share some information with you pertaining to parental plans. If we talk about parental plans, we obviously have firstly to have to look at the Children's Act, Act 38 of 2005, which sets out the requirements and formalities of a parenting plan. You may ask, then what is the difference between a settlement agreement and a parenting plan? Usually in court, you have a settlement agreement, which entails aspects pertaining to the division of the estate or maintenance towards the other party. But the parenting plan is only pertaining to the issues of the children, pertaining to contact and how the upbringing of the children, which I will discuss a bit later. So it's only pertaining to minor children and the raising of the minor children by the parents. So I will discuss the content of the parental plan in general, and also I will speak about the requirements as envisaged in the Children Act, but just in summary. So the end of a party's relationship is not the end of the parenting relationship. And it's, and the parental responsibilities that they still have towards their minor children. The Children Act requires the best interest of the children should be paramount in all matters concerning minor children, including when the marriage relationship then comes to an end. The Children Act encourages the development of a parenting plan between the parties, and the parenting plan then to be incorporated into the settlement agreement when the divorce order is then granted. Usually in the divorce proceedings, the reasonable contact rights are set out in a standard settlement agreement. However, we often see in practice, and that is what Ranier also referred to, as the contact rights were not set out in adequate detail, and that causes future conflict. And we must remember that a parenting plan is not a generic document at all. Each family has different needs. So during mediation, a parenting plan will be drafted, setting out the parents' responsibilities and rights in as much detail as possible for that specific family and the children involved. For example, a normal settlement agreement usually stipulates that each party may have contact with the children on Father's Day and Mother's Day, for example. But what if that specific day falls then on the day during which the children is with the other parent on the weekend, because it's usually on weekends? What then? Or what if the settlement agreement stipulates that each parent may have contact with a minor child on that child's birthday? What do we do then if the birthday is during the week and the father may only see the children every second weekend? It's very vague. A vague settlement agreement always leads to conflict. And that can be prevented by a proper parenting plan drawn up by a mediator that knows what to look for and what needs to be included in this plan. A parenting plan then compiled with the mediator will address all these issues. And you must remember, if there's conflict between the parents, usually there will be a conflict with the children as well. The children needs to be protected. And that's why a proper parenting plan will also protect the children, that there's no issue that in the parenting plan that can be disputed. Every parent knows exactly what their responsibilities and rights are towards their children. So then we can ask, the following question is, when do we need a parenting plan? Well, as Viraj stipulated, that it can be drawn up either when the marriage relationship has come to an end and both parties then agree that they want to draw up a parenting plan in which the detail pertaining to parental responsibilities and rights are set out towards their children. Alternatively, you can also, after the divorce, you can draw up a parenting plan if one parent would have a problem with exercising its rights and responsibilities. Then you can also ask for a parenting plan, maybe to be drawn up even for instance, there was only a settlement agreement in this divorce, then you can draw up the parenting plan to detail the responsibilities and rights pertaining to the children then after the divorce. So a parenting plan can thus be drawn up at any time after the relationship has come to an end. However, I would suggest the best, it's just a suggestion when I see it in practice, is to draw this up before the divorce is finalized. The parenting plan is made a decree of divorce together with a settlement agreement. So both these agreements are then an order of court. And as Rene stipulated, if one of the parties do not comply with the terms of the parenting plan, it's a contempt of court. There's an application that can be brought. So the parenting plan becomes part of the divorce order, and both parents are then binded by all the terms stipulated in these two documents. So if we can summary say, what is a parenting plan? In essence, a parenting plan, it's a legal document, and it's the formalities is then set out in the Children's Act. But in essence, it is an agreement between the two parents, the co-holders of parental responsibilities and rights, and towards the contact towards their children and how the children will be raised. So it's actually an agreement between the parents. In terms of Section 33, subsection 2 of the Children's Act, parents who experience difficulties in exercising their responsibilities and rights must first seek to agree on a parenting plan determining their respective responsibilities and rights. So before you go to court, before the intervention of the court, it's mandatory for you to first approach a mediator and to mediate that issue. Section 33, subsection 5 of the Act also stipulates when a parenting plan is drafted, the parties must seek the assistance of the family advocate or a mediator. This is also a mandatory clause. So there's no choice about this. That needs to be done. You need to approach the qualified mediator, or as it stipulates, if you're in person, we can approach a family advocate. And you must try, in terms of the Children's Act, to try and solve the issues before you approach the court. So it is mandatory to mediate. Now, you can ask, how do we draw up a parenting plan? What should be in the parenting plan? So that is Section 33 of the Children's Act stipulates in detail the requirements that you need to put in your parenting plan. So a parenting plan can be drawn up by a social worker. There can be a psychologist involved, a suitable qualified person the Act talks about, and that will be a mediator, which can also be an attorney or an advocate which is qualified then also as a mediator. It might take a few sessions, as Viraj stipulated, to come up with the proper terms of the mediation and what you want to put in the parenting plan. And obviously, you can also consider to be done individually or together, depending on the circumstances of every family. We all know some divorces are more difficult than others. So then at the end of the day, the parents' decisions will then be documented in the parenting plan. Most important, in terms of Section 33, as I've already said, subsection 4, the parenting plan must comply with the best interest of the child standard as set out in Section 7 of the Children's Act. There's a whole list of what is in the best interest of children, and your parental plan must comply with that. Secondly, the plan must be in writing, and both the parties, parents, must sign this agreement. It then must be registered either with a family advocate, and then also what you need to do to make this binding, when you registered it with the family advocate, you'll have to have a copy of the plan and also a statement of the social worker or the family advocate or the psychologist who assisted you during drafting of this parental plan. There needs to be a statement from that person to say that this document was drafted in my presence and during our sessions. Also, if you use a mediator, that mediator also needs to make a statement to say this plan was prepared during mediation, and this was the agreement between the parties. Aspects that I can also say and that needs to be then also stipulated in the act is also, firstly, which parent will have primary residence, and then a detailed set out of the other parent's reasonable contact rights pertaining to his children, very detailed. Access of children, of parents to children will include access of third parties as well. What about the grandmother, grandfather, and extended family? That should be included to lessen future conflict. Each party's financial responsibilities can be set out in your parental plan. However, I've seen that the maintenance aspect sometimes is included in the settlement agreement. But you can include it in detail in your parental plan. Then, in detail pertaining to contact with the children, the rotation of your major holidays, birthdays, and any other special event, that needs to be stipulated in detail and not a vague settlement, like in a settlement agreement that one shoe fits all type of agreement. Then also health provisions, medical aid coverage, medical consent, what will happen if one party is not available. And then the last thing which I see sometimes is missed is, what about a contribution that needs to be paid if the medical aid does not pay the entire bill? Who will pay the contribution? How will that work? If mom takes the child to the doctor, must she email the invoice to father? In detail, that aspect needs to be included in your parental plan. Then also the aspect of discipline, you can insert that in your parental plan. Also something like, at which age will we provide our child with a cell phone? That can be a point of argument. So if you insert that now in your parental plan, there will be no conflict in the future. Very important, religion affiliation and also religious ceremonies. How will that work? Will the father take the children when he has the children on weekends? That's very important. Schooling of the children, which language the children will they will speak at home or at school, the type of school, as well as agree to the extramural activities. That's very important to include that. And then lastly, what I see is often missed is the aspect that needs to be considered. For example, there's now a new partner in mother's life or the father's life. How will the child be introduced to that new partner? Will there be a time period? I've seen 3 months, I've seen 6 months, that the party still needs to be in a relationship before the children are then introduced to this new partner. Will it be a phased-in contact? So that must be set out in absolute detail to reduce conflict in the future. Then the following, I think Viraj also touched on this. May my child or our children take part in drawing up of the parental plan? Yes, definitely. In terms of Section 10 and Section 31 of the Children's Act, child participation is required, given their age, obviously, and their maturity and the stage of development. That is why mediation is such an ideal process. For the children to be part of it, it's a more informal process for them to be part of the process. The children, for example, can have a question like, who will pay for my music lessons? Who's going to take me to cricket if dad has me on Wednesday afternoons? And the children, it's important for them to have the opportunity to ask that questions. And it's also important that questions get answered. So once the parenting plan is complete, it's necessary to work through the children on the level that they understand, and to make sure that they know how things will work in the future. And this is also, it's mandatory, because in terms of the Children's Act and in practice, in your settlement agreement and in your parental plan, you have to confirm to the judge that you have discussed the arrangements that you've made pertaining to the children with the children. Then a lot of questions that we have is now, there's now a parental plan in place. My husband's habits have changed. What do I do now? What can I do? So a parental plan are made up with the information, usually with the information available to the parents at the stage when you sign that. So circumstances do change, and then the parental plan must be revised. You may approach a social worker or psychologist or a mediator to enter into new discussions and make changes to the plan, considering the new circumstances. In terms of Section 34 and subsection 4 thereof, a parental plan is registered with a family advocate, and it may then be amended or terminated by the family advocate on application by both co-holders of the responsibilities and rights. So you can approach the family advocate on application. Subsection 5 also stipulates that a parenting plan that was made in order of court may also be amended or even terminated, and only by application to the court, at the court who granted the order initially. So for future disputes, I also would suggest that you also address this in your parental plan. How will you handle future disputes pertaining to the children, and how will that disputes will be resolved while you're drafting this parental plan? The party should also decide what will be done if they cannot agree, for example, on a specific mediator. So you say, all right, if there's a dispute pertaining to school, we will approach a mediator. But it cannot be, you cannot stop there. You need to decide then, if you cannot agree on which mediator, you will have to appoint an impartial third party to decide then which mediator needs to be appointed. I've seen in my line of practice, for example, the chairperson of the Legal Practice Council was approached, or even the chairperson of the Arbitration Foundation of South Africa was approached to appoint a proper mediator, then with the necessary qualifications in family law that can assist the parties. And then the parties don't have you don't have a say, because then that's the last say, and that's the mediator who will assist you during the mediation. So then I often also hear that, what can a parent do when the other parent does not comply with the terms as set out in the parental plan which they've agreed on? So as Ranier stipulated, the parental plan becomes a legally binding document when it is incorporated in your divorce order, in the children's court, or even registered at the family advocate's offices. So both parties are legally required to comply with the content of the parental plan. If a parent does not fulfill their responsibilities and their rights and their parental responsibilities, they can be taken to the maintenance court, if maintenance was included in your parental plan, or to the children's court or the high court with the necessary jurisdiction for a remedy. And that will always be on an application when you approach the children's court and the maintenance court. As Rene stipulated, that if there can be a contempt of court application, and that can mean jail time, it can mean fines if the father or the mother does not comply with the terms of what is set out in the parental plan. If maintenance is the issue and you go to the maintenance court, there can always be the maintenance court can then say that the consequences will be that there's a garnishing order granted or issued against a specific party. So there's a lot that you can do. It's not the end of the road if there's a parental plan and one of the parties does not comply with what you've agreed on. So yes, that's it in short. That concludes my presentation, and I thank you for your time.
Thank you. Thank you very much, Liana. Very, very informative. And I see a number of questions that came through during your presentation. Ladies and gentlemen, however, due to time constraints, we will not be able to answer all your questions right away, but the speakers will remain available afterwards to go through the questions and to answer those that they can answer. You are therefore welcome to remain online. We still have two speakers, Nasli and Gunter, that will also present. I'm going to hand over to Nasli, whereafter directly thereafter, Gunter, you can take over from Nasli, and then Viraj will lead the team in terms of the questions and possible advice. And I see a lot of questions pertaining to specifics, information. Maybe consider contacting info@mediate.co.za for the contact details of either Nasli, Liana, any of the speakers today for further assistance. Right, Nasli, thank you very much. You are welcome to proceed.
Hi again, everybody. So this section of the webinar is specifically about an attorney's duty and responsibilities when it comes to the Rule 41A and when it comes to mediation. And then also, what is the consequences of not considering mediation or not mediating? So something that we have noticed with the new Rule 43, as Ranier has mentioned, it came into effect on the 9th of March now of this year. Because we have an adversarial civil justice system, meaning our courts, our civil courts, are aimed at two parties in litigation, that is in the arena, that is fighting it out in front of a judge or a magistrate, who then ultimately, based on the evidence before it, decides what is happening to each party, or what is each party position, and what each party gets to take, or what each party shouldn't do, or what each party should do. But now with the Rule 41A, this is a rule that obliges attorneys to recommend or to consider mediation, not just the attorneys, but actually the participants to the legal action or the application. So what does this mean out of an attorney's point of view? I also want those people who are not attorneys, they must remember that they are the litigant in the matter. So whatever the consequences of not mediating will filter through to you. Possibly in the form of a cost order, which I will explain later. But this is not just for the attorneys, this is for you as a litigant as well, because you instruct your attorney, you tell your attorney what your instructions are, and your attorney will convey it to the court and to the other party. So what is happening right now is that because we have this adversarial justice system, attorneys are finding it very difficult to implement this rule. Okay, what I mean by that is, as soon as you get a summons, an attorney's the response is immediately to file a notice of intention to defend, and then to file a plea. Okay, but what this rule now says is, this rule says before you approach the court with any action that you're going to institute, with any application that you're going to issue, you now have a duty, or it's the law now that you have to complete a Form 27, which is in the Rule 41A, in which you give the other party an indication of whether you are willing to mediate your dispute. And what makes it even more difficult is that you will have to explain to the other party, and eventually the court, because I'm going to tell you where this form will come into play, you will have to explain to the other party why you think this dispute is not mediatable. Okay, so because the attorneys are now struggling to implement this rule, and because there's not really case law where this rule has been implemented, attorneys are trying to find they're trying to find their feet with this rule. But now the consequences of not mediating, if we indicate in that form, I do not want to mediate. And the reason why I do not want to mediate is because I feel I can't talk to this person. I feel like this person is going to say no, whatever the case might be. If that attorney does not look at all the facts and recommend to his client, listen, I understand that you're feeling hurt or emotional. I understand that the children you want the best for your children, but we are now required to consider mediation. There are so many benefits to mediating family disputes, especially in family law. In family law, there are emotions involved. There are time involved. If you are a mother or a father, we all know how time it takes to raise a family, to keep your house. So in family law, it is just so much more pressing for an issue to be resolved. Money is often, I see many of the questions involved, you know, I don't have the money to litigate, I don't have the time to do this and this. But the attorney's duty to recommend or to consider mediation or to tell the client to do that, at the end, towards a hearing, any court hearing, there is going to be what you call a cost hearing. This is where the judge or the magistrate looks at the conduct of the parties during the litigation. Usually cost follows the result, meaning usually whoever won the action or whoever won the application, that person is going to be entitled. Sometimes it's not the case. That person is going to be entitled to their costs. But now what happens if the court looks at you, because the court only gets at the end, the court gets this, the form 27. The judge will then look at this form and see, but this was mediatable. Why did we just spend 500,000 Rand on divorce litigation if this could have been mediated at the Institute of Mediation of South Africa? Why are we here? Why did we spend 500,000 Rand? Now the judge looked at two things. Were you advised by your attorney to consider mediation? If you say no, there is a possibility that your attorney's fees will be capped or maybe even disposed of, who knows. In 2009, there was a judgment, Brownlee versus Brownlee. In that matter, it was a contentious divorce matter. They were fighting about division of assets. They were fighting about maintenance. They were fighting about care and contact arrangements in respect of the minor children. When this matter eventually came to trial, when judgment was eventually made, the judge found that the disputes that was in this matter could have been mediated. And the judge did not look favorably upon the attorneys who did not advise their clients that the matter should be or could be referred to mediation. The judge then ordered that the attorneys can only charge party costs and not attorney-owned client costs, meaning there's a scale A, scale B. It's where the attorney could have asked for party 1,000 Rand for a letter, he must now maybe ask 250 Rand because that's what the scale says. Okay, and then also the litigants to the matter was ordered to cover their own costs, meaning in this case, regardless of what the attorneys now did, the parties had to pay their own costs, even the successful litigant. So the attorney, for me, even when I answered a question earlier, when the person asked, you know, what must she do, and I recommended, or not recommended, but I gave guidance that, you know, you can approach the court, you can do a Rule 58 and all of that. I understand that attorneys are struggling to get used to this new thing of referring to mediation first. But it is so crucial that attorneys familiarize themselves with the process of mediation, with the purpose of mediation, because you are going to be hit with a cost order at the end. your clients are going to be ordered to pay their own costs if you do not. So at this point in time, this Brownlee judgment came from 2009. I believe the action was instituted in 2008. So just because Rule 41A came in now in March, I mean, it just shows that the courts has long, or at least I think it was the South Gauteng High Court, the court was already starting to look at mediation as an alternative to litigation, because number one is it's expensive. A trial is expensive. Expert witnesses are expensive. Even in the division of marital property, many parties believe that the attorney can quickly say, listen, it's fine. The judge will find that the marital property must be split 50-50 because you are married in community of property. But what many people do not keep in mind is that the court cannot say the car is yours, the building is yours, the house is yours, the parrot is yours. The court can only order that a liquidator or a receiver be appointed to divide the marital assets. So who is this person? This person needs to be paid. This person needs to investigate what assets they are. They need to take inventory. If one of the parties claim that the other party is hiding assets, they literally need to investigate where are these hidden assets. But the terrible thing about the liquidator or the receiver being appointed here is that that cost comes out of the joint estate. So where you now look forward to your 50, which you calculated in your head is going to be about 2 million rand. No, it's not going to be 2 million rand anymore, because your 50 is now going to be chowed into by your 50 of the liquidator's costs. But the attorneys must advise their clients of these things, and this can be resolved in mediation. In mediation, there will be reality testing, for example. The mediator will explain to the parties the worst case scenario, the best case scenario. So the parties will be able to keep control of the outcome, meaning the judge doesn't decide, the receiver is now appointed, you are going to get 50% contact with your child. No, she doesn't have to go on Wednesdays. Yes, you and your husband in this divorce process, or your partner in a civil union, you decide what suits your family with the mediator. You decide what fits your circumstances. You decide that, listen, we're not going to appoint a liquidator, or the court doesn't have to appoint a liquidator for 120,000 rand fees to divide the assets. We, with the help of the mediator, we can be guided towards that outcome. We can be guided towards that outcome. I wanted to mention again the Brownlee judgment. I cannot stress enough the importance of lawyers or of attorneys in divorce litigation. I cannot stress it enough. Apart from the fact that the attorney can be ordered actually cost in their personal capacity, which is called cost, the bonus propus, where the attorney has to actually pay the legal fees, okay? Apart from all of the cost aspects, but the strain it puts on the families to go through the litigation process, the money that you need to pay. I mean, we are now, I had a matter where we were only at the interim hearing. It was not even the trial yet. It was not even the expert witnesses involved yet. It was only an interim order for Rule 43 that we needed to oppose. That Rule 43 alone, just to oppose it, was in excess of 45,000 rand. And you know what? In my humble opinion, that was mediatable. The parties could have mediated. The attorney should have said, listen, this can be mediated. You are paying 16,000 rand a month now to maintain the other party on the interim. She only wants 1,000 rand more per month, okay? Either you pay 1,000 rand per month more until divorce is settled. If you want to go mediate about this and see where you can accommodate each other, or pay 45,000 rand to go and oppose the Rule 43. And for me, it was particularly sad that the attorney did not make an effort to to tell the party or to tell their client, listen, it's the 45,000 Rand, or go to the institute, the Mediation Institute of South Africa, and go and mediate it. It would not have been even close to 45,000 Rand. So to summarize, your duty as an attorney, and then also this is for the clients as well, because remember, an attorney is a creature of instruction. You instruct, you know now what mediation, the purpose of mediation is. You know now that the mediator assists you to guide. It's an unbiased party. It's an impartial person that sits there guiding you. So you need to instruct your attorney that apart from the fact that there is a Rule 41A that actually obliges them to go and mediate, that you want to mediate instead of going on 45,000 Rand Wanga loan to go and fight something that could have been resolved. So just to summarize quickly, advise you or instruct your attorney that you need to. I'm telling you this because I see the devastating impact of hardcore litigation on matters that can be mediated. Instruct your attorney that you want to mediate the matter. Go agree to a mediator. Okay, you can contact us, make an appointment for a pre-mediation meeting, see what it's all about, take it from there. Keep cost in mind. Your attorney's fees are going to be capped, or they're going to be held liable in the personal capacity if you are unreasonable and you do not want to mediate for unreasonable reasons. So we cannot go into that right now. You are going to not get costs. So even if you are successful in your matter, where you were looking forward to having your costs paid, it's not going to be paid because you brought the matter to trial that you could have mediated. And just to state this as well, it's paramount in family law matters, especially when there's children involved, to not only consider mediation, but to actually give it a go. The time, the money, you have nothing to lose. It is a voluntary process. It is without prejudice, meaning if the mediation fails and you go to court, the other party is not allowed to use against you any offers or tenders or concessions that was made during the mediation. So there is nothing to lose apart from a 1 hour or 2 hours session, 2 or 3 sessions. That in comparison to a 500,000 Rand divorce trial, to me, it's no contest. So I hope I've explained myself clearly. And if you have any questions, you can direct it at the institution, the mediation institution, or you can, I don't know, Jan will tell you how to contact, because our time is very limited, and so we can't answer all the questions now. But thank you for having me again, the Institute, and then also thank you for joining us here.
Thank you very much, Nazli. And I think just to let everyone know, Jan has another engagement that he'd attend to. We're always, if everyone could switch their cameras on if you're here, we're always here to give you, our attendees, the best information, as much information as we possibly can. We would have had Gunther in as well. Gunther, do you have time that you want to take up now?
Good afternoon, Viraj. Yes, I'll make it short and sweet.
Okay.
If you will allow me. Thank you so much for the time. Good afternoon, everybody. I am here to speak very briefly about mediation in family businesses. Now, we'll have to start off with, how does a family business differ from a normal business? And hearing all our other insightful speakers, it's clear. Family disputes are emotionally charged. What's also important, that dynamics differ. Now, how do you measure the success of a family business as opposed to that of a normal business? A normal business, its success is measured by income, by its return, by its market share, whereas a family business, in the general sense, it goes further. A family business success is measured by its legacy. It's measured by its impact on the community. It's measured by not only job security for the family and its members, but also job satisfaction. Now, having said that, Nazli, right before I'm speaking now, mentioned the adversarial court and litigation system we have in South Africa. The court looks at the facts. The court is not concerned with the legacy. The court is not concerned with the impact on the community in the sense of a family business. The court is not concerned with job satisfaction. In the court system, there's a winner and there's a loser. In a family business, if there's a dispute in a family business and that dispute goes to court, the family will be the winner and the family will be the loser. The business preservation and success has a direct impact on the well-being of the family, more often than not. Where a dispute comes in is where a competent mediator can assist the parties to navigate their overlapping interests, in this case, the family's interest, and can help the parties to resolve the issue amicably, coming to that solution that suits both the family as well as that of the business. And that's why family disputes should be mediated and not be resorted to resolving conflicts in court. Thank you, Viraj.
Thank you, Gunther. Thank you for your time. And again, everyone, thank you so much for staying on. We're going to try and take a few questions. I do understand we've run completely out of time. Our panelists and our speakers do want to give you as much information as possible, and we're going to try and answer a few questions. So those speakers that are here, if you could just switch your cameras on and unmute yourselves, please. We've looked at the questions. So if there's anything you see that you want to answer, guys, please take it on and answer it.
Yes.
Yes,
Sorry.
Naz.
Yes, I would like to answer the one about, do you believe an attorney can rely on the requirement of mediation to advise the opposing attorney that communication between the parties should be between themselves and not through the attorneys? I am thinking, I wasn't sure if I'm understanding that question correctly, but if you are legally represented, of course, you and the party can talk to each other directly, but of course, it is not recommended that you speak to the other party directly if you are legally represented. And you cannot use the rule of mediation to block out the other attorney and saying, listen, you cannot be communicated with by the two parties, or the two parties must talk to each other, not to the attorneys. You cannot use the rule of mediation to block out, stall that communication between the parties. I hope I'm understanding the question correctly. But basically, the only thing that is blocked out when it comes to this is whether you can mention the offers that was made and whether you can mention the concessions and the admissions that was made during mediation. That cannot be revealed to the court until later at the end, but even that is contentious because in the rule, I believe it's subsection 8B, D, and 9B, where it says that the court can use it to make cost orders. We're not clear on that yet because mediation is confidential, so that is yet to be seen. But no, you cannot use mediation rule to block out the parties from communicating with their lawyers. They must communicate with their lawyers.
Thank you, Nasli. Liana, there's a question here about the parental plan. Liana?
Yes.
It says the parental plan is only for minor children and excludes major children who are full-time students and dependent on parents. If so, what are the rights of the major children?
Well, obviously, the major children, both parents have a responsibility to maintain their children until they can obviously pay for themselves. So if they still study, both parents have the responsibility to pay accordingly their income, so proportionally. So the child may approach the maintenance court, for example, which is difficult when to do that when you're a child. But usually I see the mothers, if the child is still living with the mother while studying, or the father while studying, will assist the children in that process in the maintenance court. But unfortunately, being major when you turn 18, then you will have to, that will be the claimant or the applicant in the matter, but their parents can assist them. And both parents are still liable to maintain those children as long as they study. Not studying while they're 40, that will be unreasonable, but when they become self-supportive after reasonable study time. Yes, Nazli, would you want to add something to that?
No, you oh, am I still unmuted? Oh, no, you good. That is exactly what I would have answered.
Thank you, Liana. We do have some questions about training. The Mediation Institute will give out information on training. And of course, it's not limited to just lawyers. So just to answer a few of you who've asked that, the training is not limited to just lawyers. Social workers can come through for training. There's a question, and I think, ladies, and if Gunther's is still there, that can there be a template for a parenting plan or an agreement that people can look at? And I'm just going to briefly say that, as we always say, that parenting plan is created for the specifics of that family and those children. So we don't want to be irresponsible and say there is a template, and all the speakers have spoken about that generic document. We don't promote that generic document because it doesn't speak to your circumstances. So ladies, if there's anything you want to add on, please do.
No,
Well,
yeah.
Sorry.
Liana?
No, sorry, Nazli, you can say, I agree with you. It cannot be. We know in terms of the Children's Act, there's specific items that needs to be listed, but how to word that and how to expand on that pertaining to, for example, the contact, mother, father, grandparents, maybe siblings living with the other parent. So it cannot be, it can never be a generic document, but we can, if they have a look at the Children's Act, where they can see on Google, the requirements are listed there in the sections that I've mentioned, just in the essence that needs to be there, but obviously it needs to expand a lot on that when you actually draft this document, and that needs to be applied at the end of the day. It must be a workable document for both parents and the children.
Yes, I agree.
Okay, and again, there's a lot.
I've seen a question, a lady asking about costs, that she's unable to pay for the attorneys that we're speaking about, to approach your attorney and so forth. I can give advice in that regard. If you the Pretoria Bar and also the Legal Practice Council has attorneys and advocates that does pro bono work. There's a list for pro bono work if you qualify for that. Also, then UNISA has a legal clinic. I'm not sure where our the lady is situated, but the universities like Tikkies also has UNISA has a clinic, a law clinic that can assist people with a salary below a specific amount. I cannot confirm what the amount is at this stage, but that's maybe something that she can consider.
Can I add on there?
Sure.
Yeah, I think this is exactly where mediation would actually resolve where a party cannot afford legal fees, because I know that someone mentioned that I do not qualify for pro bono legal assistance because my salary is maybe just above the threshold. And I know that this is a problem to many people. Many people are lingering somewhere just above the threshold, and many of these pro bono institutions doesn't go a dime over their minimum salary. But this is exactly where mediation would assist you, because with mediation you would know upfront what will be the cost of mediating a session. Many people uses 1, 2, 3 sessions. In general, it can be some disputes are resolved in 1 or 2 or maybe even 3 sessions, but at least you will have clarity on what the fee is going to be. Oftentimes the parties split the fee 50-50. The major thing is that there's no litigation. You will not need a lawyer to go and file lots of papers and do lots of things. Or maybe even if you are in a divorce and you can mediate a settlement agreement, it can go through on an unopposed basis. Many attorneys ask fixed fees for uncontested divorces because it's so predictable. There's a settlement agreement signed that was mediated. It needs to go issue. The other party already know they need to go to the sheriff office to go and be served. They already know that you need to wait 10 days and then it's going to go be set down on the unopposed roll. Only the plaintiff appears. So the attorney is maybe going to ask you between maybe 6,000 and 7,000 Rand. So now you know there's definitely a cost of 7,000 Rand. This is an example. So I need to either save up for that or I can make maybe a small loan for that, which I wouldn't recommend. Rather try and make an arrangement with an attorney, but do not, if you approach the attorney with the aim of litigating and you cannot afford it, do not do it because you're going to be crippled financially. Rather tell the attorney, listen, I want to get divorced from my husband. I'm telling you up front, I cannot afford the legal fees. I want to consider mediation or I want to mediate. Please contact the other party and feel what their position is. At least you know what the other party is thinking with regards to mediation. And you know what? If it gets sorted out in 2 sessions, maybe it's going to set you back. I don't know what the rates would be quoted, but now you know there's 7,000. Now you know there's maybe 1,500 Rand an hour or 2,000, but you know exactly what you need to prepare for. This is perfect case where you can mediate instead of not qualifying for pro bono assistance.
Yes,
Thank
I
you.
agree.
Thank you, Naz. Thank you, ladies. I'm just going to take one more question. If you see anything else that you want to answer, please do. I guess I'm still mindful of time and I'm still appreciative of those who are still here in attendance. If the parenting plan was completed by the family advocate and now changes need to be changed, does it have to go back to the originator of the parenting plan, or can a new person draft a new plan?
I'm
Yes.
sure. Yes. Sorry, Nazli. I don't know if you want. Yeah, you can answer that. It's fine.
Oh, no, you can go ahead. I was just saying yes.
Oh, all right. Yes, I don't think there's a specific that you need to go to the initial a person that assisted you. You can obviously approach a new, maybe you're not living in the same town anymore. So you can definitely approach a new mediator who can assist you and help you with the drafting of that. It's only, as I've stated in terms of the Act, that it needs to be submitted on application to the court, which granted the order initially. That will the only requirement be. So if you're somewhere else at that stage, you will just have to get an attorney or something just to file the application to the court where it was originally granted. So I don't think you need to use, you don't need to use the original mediator or psychologist or family advocate that assisted you.
I see there is a question, if my ex does not comply with the maintenance agreement, which formed part of the divorce settlement, can I approach the court directly or must I contact the lawyer who was dealing with our divorce? So any matter pertaining to maintenance or contact and care arrangements in respect of children, it doesn't matter if this was finalized in the High Court, the divorce decree, or if it was done in the regional court. If anything needs to be varied as far as it pertains to the children or to maintenance, you can approach the maintenance court or the children's court to go and do the amendment. But again, I would stress that before you do that, you contact our institution and you mediate a new parenting plan or a new maintenance agreement, because even though maintenance court is not free, yes, it is free. If you're going to approach the maintenance court, you can do it yourself. You don't really need an attorney in maintenance court. But it is the reality that even though it's supposed to be a public-friendly process, it's often not. It is usually there's some sort of a legal foundation required, even if it's just Googling it. But I mean, again, mediate about it, contact the mediator, tell the other party, listen, let's go and mediate a new arrangement so that the maintenance order that is embodied in the divorce decree can be varied so that it can suit the new circumstances, because the child now went to high school, or the child needs to get a surgery that's going to be expensive, or there's a major change in circumstances, because it does happen that there's sometimes good cause for a maintenance order to be varied that was made even in a divorce decree that was issued by the High Court. But you do not have to go to the court that granted the decree. You go to the maintenance court, or you go to the children's court, and yes, even the court will recommend that you go to go and mediate first, or to the family advocate. So either way, you are most likely going to be directed by the magistrate to go and mediate the parenting plan or a new maintenance agreement. Thank you.
Okay. So I've also looked at all the questions, and some of them are very specific, which would require advice for your specific circumstances, ladies and gentlemen. So we are not going to answer them here because we don't advise on our platforms. We give information. Please contact info@mediate.co.za. And as you can see, it's a panel of specialists, of attorneys, of advocates, and we are all here to help you mediate. We're going to also assist you where advice is needed. We cannot take some of these questions online, and we would prefer to deal with them with you one-on-one. And again, I want to thank, there's still so many people online. I don't know if you ladies can see it as well. And we really do want to get to each one of you and assist you and give you as much information. If we need to, we will run another session. So I want to say thank you to our speakers who have stayed behind, and of course our speakers who gave us time today. Thank you, ladies, for remaining to answer questions. And thank you so much to our attendees for being here with us. Look out, watch the space. There's going to be more sessions, and you're going to be receiving a lot more information from the Mediation Institute. So again, look out in your email, look out on social media, and we're still going to be coming back at you with lots of information for your assistance.
Yes.
So good afternoon, everyone. Thank you all very much. And I'm going to end. Is there anything else?
Thank you, Viraj. Thank you.
Thank you so much.
All right. Thank you, everybody.
Bye, Natalie.
Bye-bye.